Completeness with Kate Kirkpatrick, the Wetland Policy Analyst for EGLE, and really excited for this. I've seen a preview. It's well worth everybody's time. So we're excited. Kate, I'm going to let you try to take the screen.
Okay, thanks, Todd. Let's make sure everybody can hear me okay too, since
Yep,
I was having some troubles earlier. Okay.
We can hear you.
And how's that look?
Looks great.
Perfect. Okay, well, thanks again, Todd. Thanks to MWA for working with us to present this topic to you all today. And thanks to you all for joining and listening. So this is the Joint Permit Application and Administrative Completeness. Today, we're going to give some background on the joint permit application and our program and talk about the requirements of Part 13 and how that really informs our application period and administrative completeness requirements. I'll also touch on some best practices with submitting the JPA in there, but a majority of this presentation is going to be going over the administrative complete checklist, which will hopefully help address a lot of those questions that applicants have. First, starting with the background on the joint permit application and our Section 404 program. Michigan is special in that it has a consolidated permitting program at the land and water interface and has assumed Section 404 of the Clean Water Act. Michigan is one of 2 states that has been approved by the federal government to administer Section 404 along with New Jersey. The Michigan legislature drafted Part 303 specifically to allow the state to assume the program. The US EPA is responsible for oversight of Michigan's administration of the 404 program, so it can assume or ensure that our program is operated in a manner that is consistent with federal law. On a similar note, we have worked with the U.S. Army Corps of Engineers to develop a joint permit application process so that only one application is needed in areas where an EGLE and U.S. Army Corps of Engineers permit are both needed, which is in those coastal areas and designated navigable rivers that are covered by Section 10 of the Federal Rivers and Harbors Act. So this slide just shows a timeline of how we created this program, starting in 1972 with the Michigan's Inland Lakes and Streams Act, the signing of MOAs, the Memorandum of Agreements between Michigan, EGLE, and the Corps, and then finally with the assumption of Michigan's own regulatory program in 1984. So unlike other states, in Michigan, a separate state and federal permit is not required in most areas of the state. So this is what we mean when we're referring to the consolidated joint permit application process. And there are also other ways that the JPA consolidates the permitting process. Under the JPA, only one application is needed under all the land and water interface programs, which includes floodplains, inland lakes and streams, wetlands, dam safety, high-risk erosion areas, Great Lakes bottomlands, and critical dunes. Instead of charging fees under all the different statutes, the single highest fee only is required for many projects. So this way, by taking over that 404 permit program, we are more efficient in administering it. We have statutory timelines. We have one form, so it allows us to streamline that review process, reduce delays, save money for applicants, and it also reduces potential conflict between federal and state permitting conditions. So one application, all sorts of federal and state authorizations. So to kind of sum that all up into one slide, the benefits of Michigan's 404 program include effective resource protection, a stable and predictable regulatory framework that provides clearer definitions than in federal regulations, faster permitting decisions through statutory mandated timeframes for permit review, our consolidated permitting program, which includes simultaneous review of multiple programs, so Section 404, joint jurisdictional projects with the Army Corps, And something I haven't mentioned yet, which is review of the coastal zone consistency and 401 water quality certification, which in other states is required from multiple agencies. We also review for state and federal threatened and endangered species and screen for historic and archaeological sites. Our program can maintain state control while remaining consistent with the federal regulations. Local field staff are able to provide more for direct and on-the-ground interaction with applicants. And there is a court-style formalized contested case appeal process, which is not the case at the federal level. Okay, let's dive into Part 13. So Part 13 of NREPA does apply to pretty much all of our resource program statutes. All of our major statutes and a few more are affected by the language in Part 13. One of the first things that Part 13 does is talk about how our review process is split into the application period and the processing period. The application period is the time when the application is received until the time the application is considered complete, and that includes that fee being paid. This period runs for 30 calendar days, and unless the processor notifies the applicant that something is missing or incomplete in those 30 days, the application is otherwise deemed complete. If we do notify the applicant that something is missing or incomplete, the application period is tolled, meaning the countdown to that 30 days has stopped. Once the application period has closed and we were able to mark it complete, then the processing period starts. That is the period EGLE staff are looking at permit review criteria. That's when they're doing their public noticing. And there are also different timelines that go with that. So there are different timeframes for different parts of NREPA. I do have a table later on that puts it in a different picture for you. But the processing period is going to vary based on which statute EGLE review falls under. Part 13 also requires that the department provide a format for the application and that those applications are submitted on that specific form. So that is our joint permit application form in MyEnviro. One of the other things that Part 13 requires is for EGLE to have a list of what is needed in a complete permit application, and that is our instructions and our administrative completeness checklist. Not only do we have to have this list, but we also have to post it on the website. Part 13 also has requirements for what happens after an application is deemed complete and what kind of additional info we can request. And this really falls into two categories. The first being new information and second, clarifying information. So for new information, if we go past the 30 days and we have a question on something that is not in the administrative completeness checklist or it's not a question on the JPA, we can request that information as long as we also provide a detailed explanation of why we were asking for that info. But the applicant is not required to supply it. This type of request doesn't come up too often, but if it does, there's typically a good reason why we're asking for that information. So applicants should just note that if they choose to not supply that information, EGLE will need to make a decision based on what has been provided. Now, the clarification request, the second bullet, is something that does happen often. After an application is complete, EGLE can ask for clarification or amplification or even a correction on information that was provided in the application. And those types of questions should be based on the information that was provided in the permit application. The applicant is required to provide that info. Once we mark it complete, we're not going to be able to change our fee requirements, for example, but maybe we're asking for amplification of feasible and prudent alternatives. Maybe we noticed that the site plans have an important feature missing, or maybe we need clarification on something that was written in the narrative portion of the JPA that's being contradicted somewhere else. stated later on or in a different document as we're going through our more detailed review. If the applicant requests an extension of their processing period deadline, EGLE is required to grant that. It should be requested in writing, and we need to document that in MyEnviro. Part 13 does say that we have to grant an extension, but it is only up to 120 days. After that, the applicant can still request an extension, but it is up to EGLE's discretion on whether to grant it beyond that initial 120 days. Depending on the purpose for the extension request, generally EGLE staff are going to want to work with the applicant to provide all the necessary information or address any remaining issues. So as long as you're communicating often and openly with EGLE, and it's not going to take another year or more to accomplish, we can work with you on the extension. Another really important point here, and why we want to pay attention to the length of the extension, is that we cannot extend the processing period more than 1 year after the application period has been marked complete. So that is something to keep an eye on. If you are a consultant, it's something that you want to make sure your clients are aware of, that final deadline where EGLE will be forced to make a decision with the information we have. And this is already in a lot of our statutes, but Part 13 also provides the ability to put conditions or to modify projects when we issue a permit. Part 13 does talk quite a bit about denials and what needs to be in a denial. It says if we're going to be denying an application, we need to provide all of the following to the extent practical. We need to be able to provide the citations in statute and rule. We need to have sufficient information to be able to make that determination, and that is documented. The decision needs to be based on reliable scientific principles and methods, which is our standard practice. It needs to rely on the facts, again, standard practice. And then under 301 and 303, we are supposed to make suggestions on how to modify the project to make it permittable. And that's not just with denials. Under 301 and 303, if we're doing a modification, then we should be documenting all of these things as well. And I'll just note here that denials are not very common. A majority of the applications, we try our best to work with the applicant to modify that before reaching that point, or they're withdrawn and submitted when additional information can be provided. Sometimes the project simply is not able to meet statutory criteria and is denied, but that happens to only about 2% of all applications received. If we miss our permit processing deadline, the applicant gets a 15% refund. The language in statute also states that we shall not discriminate against those who ask for the refund, and we need to process that as normally for going over the deadline. So it doesn't just go to the bottom of the pile because the deadline is passed. We're still processing it in the manner that it was received based on the type of permit that it is. Part 13 also requires us to coordinate how the applications are processed under all the statutes in Part 13, which is, again, pretty much all of our resource program statutes. So when there are big files that require something from other divisions or a mining project, for example, we all try to talk and coordinate with the other divisions. Reporting, every year we have to submit a report to the legislature, and that includes how many applications were received, how many were denied, how long it took for those applications to be marked complete, how long the processing deadlines were on average, and how many were not complete when we received them, and then the amount of money refunded if we went past our deadlines. And then here's that helpful chart I was talking about earlier on application and processing periods. These are not additive, so once the application is determined to be complete, the processing period starts, even if we still have time left in the 30 days. So this is a really important point here too, at the bottom there. When an application is being processed under multiple statutes, the shortest deadline is what needs to be followed. So if you have a 301 file, that's 60 days. but it's also being reviewed under 303, which is 90 days, your processing period is going to be 60 days, the shorter of the two. The shorter deadline is calculated for EGLE staff automatically internally once the application is marked complete. So we are able to provide you with the processing deadline once we reach that point. If an extension is provided, that is the new processing period deadline for the project as a whole. But applicants should note that wetland applications do not auto issue until the 90th day or the extended date, if it's extended. And just to give you an idea on some numbers, here are the statewide Part 13 averages for fiscal year 2024 that are from our Part 13 report. As you can see, last fiscal year, which is from October 1st to September 30th, we received 4,425 applications. We issued 3,816 of them. 618 of the applications were withdrawn, and 93, about 2% of all the applications received, were denied. Applications are withdrawn for several reasons. The applicant may no longer be interested in the project. The application may have been modified significantly enough that a resubmission makes more sense. There could be a delay in the project planning and the applicant resubmits later on, or the application is withdrawn to avoid a denial. As you can see, our average time to determine completeness is 18 days, and average time to approve applications is 43 days, according to the Part 13 report. But obviously, this report doesn't separate out the different application types, which plays a big role. So this is a statewide average. It includes general permit authorization, minor projects, and individual permits for the different programs all together. Okay, so now we're going to dive into the nitty-gritty of the application period and administrative completeness. And just to check in and summarize everything really quickly, application completeness under Part 13 means that it has to be submitted on one form, which is the JPA. There's got to be the detailed list of information that's required in order to submit the permit, which is the instructions and the administrative completeness checklist. But it also, correction requests must be sent out within the 30 days upon receiving the applications, which would then toll the timeline. Part 13 identifies the kind of information we can ask, whether that is new information requests versus a clarification request after the file is marked complete. And I'll plug our website. It has a lot of different help documents as it pertains to MyEnviro, the JPA, the permit categories. So please check out michigan.gov/joint permit. And you'll also find FAQs. There's a flow chart showing the overall permit process, sample drawings, specific project assistance and guidance, and then links to other programs and helpful materials. Okay, now let's talk specifically about what we need for administrative completeness. First of all, the digital JPA does do a lot to make sure that the basic information is completed. So that helps a lot. It requires the applicant to complete certain questions in order to even be able to submit the application. However, it is still EGLE staff responsibility to check those answers and make sure that they're done correctly, honestly, and completely. Also, throughout the entire JPA, there are helpful information bubbles to help applicants understand how to answer the questions and what information to provide. In some places, there are even links in the bubbles to help applicants find additional clarification. And the JPA does have a lot of sections and questions, but it has been designed to go through a logical sequence and help applicants understand what is being asked for by providing descriptions and the pop-up informational bubbles. So this is a screenshot of the application on the public-facing side and what happens when someone tries to skip a question. It will highlight it red, and then additional information pops up that is intended to help the applicant better understand what is required for the question. But here's a screenshot of a section in the JPA where document submission is optional per the rules of the form, but it still might be information that's needed. And so there are a lot of areas in the JPA that can easily be avoided or incorrectly answered. So these optional opportunities are, or optional questions are really opportunities for applicants to provide additional information or attachments as needed. Providing information here can often help our review process, sometimes making the review easier, quicker. For example, a question asking if the permit number under which previous dredging was allowed is optional because applicants may not always have that information. But when it is provided, our staff are able to quickly and easily look back at the previous application and permit, which can be very helpful in the review process. So here's what the checklist, this is where it can come in handy to help applicants understand what we really need. This is what it looks like. It is divided out by section titles and has 4 columns. The item question, typically associated with a verbatim question in the JPA. Additional information where the applicant is provided with clarification on the question or section in the JPA. An actual checklist column as you're completing the application to help you keep organized, or for EGLE staff to help with their review. And then a notes column for any comments or items you want to keep track of. For applicants, maybe you want to note something to follow up on or contact EGLE staff about. And for EGLE staff, that can be the same. The checklist is for all the JPA applications. So this is intended to be a supplement to the required questions of the JPA, and also to be used as an organizational tool for applicants and EGLE staff. It does follow the JPA format, and it provides additional information and considerations for the applicants by including a lot of the notes that are derived from the informational pop-ups in the JPA that are often missed. And now I'm going to go through each section of the checklist and give you the rundown of the bigger items and questions for each section. So starting with the first section in the JPA, which is contact information, the checklist asked, has all relevant contact information for the applicant, agent, property owner, etc., been provided? And then provides an additional note that says email addresses and phone numbers for the potential permittee and all relevant notification recipients must be provided. Electronic communication is really the main form of communication for EGLE, including how our permits are issued. So email addresses are pretty important for a clear process of the permit application. However, we do get this question, what if the applicant does not have an email address? And we recognize that there are plenty of people in Michigan, especially in more remote communities, where the applicant doesn't have any email. But unless you provide that explanation in the application, this is likely still to be an initial correction request, but EGLE will work with the applicant on other methods of communication and communicating the correction request. So it might be a lot of phone calls or mail, or maybe even a relative that is able to assist as an agent in the case, but the EGLE staff are completely willing to work with the applicant in that case. Next section in the checklist, and one that deserved its own section, is letters of authorization. There are several checklist questions that help provide clarification on when those letters of authorization are needed. How does that situation change if there are easements, etc.? So starting with, if the applicant is an easement holder, has the applicant submitted easement documentation if necessary? For projects in new easement areas, for example, new utility corridors, easement documentation for the parcels that have proposed regulated impacts, so not the whole line, just the parcels with the regulated activities, need to provide that documentation. If the project is in an area with an existing easement, For example, a long-standing utility easement with only maintenance or improvement activities proposed, that documentation is not required. We just ask that the easement boundaries are then indicated on the site plans as typical. If an agent or consultant is submitting on behalf of the property owner, has a letter of authorization been provided that clearly states the applicant, meaning the agent, is able to submit the JPA on behalf of the property owner? That letter of authorization has to have a quote unquote wet ink signature, meaning it's their actual signature. Emails, unsigned Word documents are not sufficient for that. Electronic signatures or scanned versions of the wet ink signature may be allowed. And then if impacts are occurring on multiple properties with multiple property owners, have letters been provided by all the property owners with regulated impacts occurring. And again, this would not be necessary for easement holder applicants within their own existing easement boundaries. Project location. A lot of the questions in this section are pretty straightforward, but there are some that need additional explanation. So first on the checklist is just to confirm that the project locations are clear and match with your site plans. This section has to be completed in order to review the site properly, make sure EGLE staff can find it for a site visit, and notify the local units of government. And so with that, has all the relevant information been completed in the JPA? A little redundant here, but this is a section of the JPA that has a lot of optional questions. So it really is an area that is easy to skip questions. So use this as sort of your double check system that you're answering the relevant questions, you're providing information on where the project is occurring, you're looking at all those info bubbles. And for this section, for linear utility transportation projects or projects with multiple easements or similar authorizations, you do not need to provide a tax ID, but you do need to provide the name of all the local units of government where regulated impacts are occurring. So EGLE is required to notify all of those units of local government, either through the public notice or if a permit is issued. Also for linear utility projects, we've had a lot of coordination and conversations with utility companies about this. So this isn't totally new information to a lot of groups. And a lot of consultants already provide this information when requested by EGLE staff. But for long linear utility projects over 1,000 linear feet in length, please provide that KMZ file in line format of the entire project. This is necessary for our federal screening requirements and will expedite our ability to screen for T&E species, contamination sites, sites of historical, archaeological significance, etc. Next section is for basic background information. So first, to your knowledge, has the applicant accurately provided information on whether construction activities have begun? So this question isn't just referring to the regulated activities, it's also referring to any construction activities, including brush clearing, site grading, equipment staging, etc. So basically, if EGLE staff were to do a site visit, what condition are they going to find it in? This section in the JPA also asks if the applicant has provided conservation easement or other easement information. This is a good check for EGLE conservation easements. There is a layer in Wetlands Map Viewer to check that. The JPA requires at least a phone number for easement holders. And then if the project involves acquiring new easements to construct, this is another spot where it tries to clarify that. So you can also upload that information here. Next section is the permit category section. So has the applicant selected all the relevant GP or MP categories for the project activities? This is a common correction request section because if the applicant has applied under GP or an MP or multiple GPs or MPs or both, and there are aspects of the project that do not meet the conditions laid out by that category, EGLE staff will send a correction request. If it seems like there's a minor tweak to the project that will allow the applicant to apply under the MPGP, EGLE staff will notify applicants of that and provide them with options on how to move forward and address that. There is an option in this section of the JPA to select unsure, which you are welcome to utilize that. It just means that a correction request will definitely be sent for that item. And similar to what I just spoke to, EGLE staff will notify the applicant of potential categories to apply under and how to best move forward. Public notice information. So this subsection will only appear if you are applying under an individual permit. But if you are correctly applying under an individual permit, you will need to include a list of all adjacent property owners for the project. So that's going to be all parcels touching and across the street from properties where the regulated activities are occurring. You'll have to provide these owners' names and mailing addresses. And then just a note that public noticing is not required under Part 31 only. So if you're just applying under a Part 31 permit, the project won't need to be public notice. And there is an option in the JPA to select floodplain only application, so you don't have to supply the list of addresses. Okay, next is the project description section. So this is really an important part of your application where you'll be setting up the project to EGLE staff and getting at why you're applying for a permit. So the applicant should be selecting all relevant options that best describes the purpose and need for the project. But for single lot residential projects, the applicant can just select private residence. Also under project description are narrative questions that summarize the project and proposed activities. So has a summary of all proposed activities been provided? Some applicants choose to submit a separate document for this, which is fine as long as you indicate that in this section. But the applicant should be providing a description of the entire project, including activities directly impacting regulated features, for example, dredge, fill, structures, or drainage, and indirectly impacting regulated features, like overland runoff, for example. Phased projects, like future development projects, subdivisions, those have to be sufficiently described or shown on site plans, and a timeline should be provided for those phases. Staff may require phased projects be applied under one permit application. Has a summary statement of the project's purpose and intended use been provided? The project purpose shall include all associated activities and shall not so narrowly define the purpose as to limit a complete feasible and prudent alternatives analysis. Has a schedule of the proposed activities been provided? Schedules must include all of the following: construction timing, methods, equipment being used, soil erosion and sedimentation control measures, estimate of project start and completion dates. A lot of projects are large and can be fairly complicated when it comes to their impacts. So these project description questions are essentially allowing EGLE to understand whether the applicant is properly accounting for all the resource impacts. Another aspect of understanding the full impact is with piecemealing. So this is something that comes up a lot with those phased projects in particular. Piecemealing is when a project is broken up into smaller or separate pieces, resulting in the avoidance of full regulatory oversight, processes, mitigation, or consideration of alternatives. If it seems like a project may be piecemealing, these are some correction request items that EGLE staff may ask the applicant to help us determine whether the project is incomplete or not. So are the projects being funded with the same funding source and time frame? Are they going to utilize the same contractor and contract? Are the projects interrelated or dependent upon each other? Essentially, could they do each project regardless of the others? Are the projects all going to be implemented within the next 5 years or so? With the project description section is also where you'll be providing your feasible and prudent alternatives analysis. So this must be a narrative description detailing all of the options considered in planning the project and describing why this project is the least impactful alternative. Avoidance and minimization efforts should be described, including other locations, configurations, sizes, materials, and methods. Any do-nothing approach being ruled out must have an explanation. The narrative should be commensurate with the scale and scope of the activities proposed, and no other options considered or a variation of that response is not a complete response. The alternatives analysis is required, and that type of response will get a correction request. So feasible and prudent alternatives analysis can garner a lot of questions. So, before you put in a bunch of questions about feasible and prudent alternatives, I do highly recommend you check out the webinar video that is on the MWA YouTube page. We do have a great training that Ann Garwood did on evaluating feasible and prudent alternatives. And then please check out our guidance document, WRD 003, for more information on that. Next section is project compensation. So this is an area where it is easy to get a correction request item because the JPA does allow for the applicant to, say no mitigation is being proposed and then be able to move on, even if they're are not proposing something that makes sense for the project or actually is possible. So this is a question that staff are checking because a conceptual compensatory mitigation plan is required for completeness for impacts to wetland over 1/3 of an acre in total and/or for significant stream channelization or relocation projects. If the project is determined to be permittable, a full compensatory mitigation plan would be required before a permit is issued. During the permit processing period, EGLE staff may also determine that mitigation is required for smaller impacts. For projects that significantly impact resources, staff will often include a note. So this would not be a correction request item, but more of a courtesy notification to the applicant that a reduction in impacts is strongly recommended before additional effort is put into a compensatory mitigation plan, especially if they would be required to provide stream mitigation or on-site mitigation. Now I'll just touch on, what a wetland conceptual mitigation plan is. It can just be a statement that the applicant will be using mitigation banking. So you should be providing information on the bank you're wanting to use so that EGLE can confirm whether those credits are available. If mitigation banking is available, that is the preferred method, but the applicant can provide an on-site mitigation proposal, and we do have the conceptual plan for this detailed on EGLE's website with a checklist of items required. For stream conceptual mitigation plan, the location of the proposed mitigation site, baseline assessments for both the impact site and mitigation site using the stream quantification tool, the SQT, a basis of design document, plan view of channel design, and a narrative discussion of site protection are required. At this stage, we don't need engineered plans, but we would need enough information from the applicant to confirm that stream mitigation is possible and likely to occur. But as you can see, these items take time, effort, commitment from the applicant. So efforts to avoid and minimize should be taken before developing a stream mitigation plan. EGLE staff will often reach out and suggest a meeting with the applicant to go over this process and see if we can coordinate earlier and discuss whether this would be a requirement or not. There are also some great webinars on the Michigan SQT process and stream mitigation by our stream specialist, Bethany Matusik. So links to the videos and the SQT manual, as well as the checklist, can be found on our EGLE stream mitigation pages. Okay, next section is activity type. So this is an important section of the JPA because this is part of the logic of the JPA. If the applicant has incorrectly or not selected an activity that should have been selected, the JPA will not generate the correct sections to complete. So All of the relevant activity types should have been selected, and if there isn't one that accurately describes it, then other activity type can be selected, and it's on the applicant to adequately explain the project impacts. Sediment testing. Is the applicant proposing a dredge volume over 2,000 cubic yards? If so, the results of sieve analysis results have to be uploaded for administrative completeness. And at this time, that can be uploaded in the additional documentation file upload at the end of the application. The checklist will also call out some additional information for specific activity types or resource types. So I'll run through those really quick. For marinas, has the applicant provided all appropriate supplemental information, such as documentation as to how the marina facility will provide watercraft, sanitary holding tank pump out services, a copy of the property legal description, mortgage survey, or property boundary survey, any available sealed riparian interest area survey and or written authorizations from affected adjoining riparian owners. For lake creations, mining, large excavation or pumping projects, has the applicant provided all appropriate supplemental information? These applications may also require hydrogeological investigation documents and or modeling information for completeness. For dams or spillways, has the applicant completed the correct section and provided all appropriate supplemental information? The dam spillway activity type is for activities as regulated under Part 315 only. The applicant must attach detailed signed and sealed engineering plans for a Part 315 dam repair, dam alteration, abandonment, or removal. Next section is for resource type. This is when staff are evaluating whether or not regulatory status of all resources has been verified, whether the applicant has appropriately considered all other regulated resources within the project activities. And this is another section that depends on the logic of the JPA. So if this is filled out incorrectly, it will not generate the appropriate sections. If wetlands are selected as a resource type, it will generate its own wetland section, and then you'll be able to put in additional compensatory mitigation information. So again, conceptual mitigation plans are required for complete application for impacts over 1/3 of an acre. And this is where professional wetland delineation information can be provided. For wetland impacts 1/3 of an acre or greater, paired wetland upland delineation data forms for each wetland and wetland type are required. And then I'll just go into that a little bit more. So wetland delineations should be performed using the Army Corps manual, regional supplemental documents, complete data sheets with paired wetland upland data points, and it must be completed or at least verified during the growing season. Keep an eye out for farmed wetlands. Farmed wetlands are regulated wetlands, and they do require a permit if the project is no longer farming related. For streams or inland lakes, has the applicant provided bankful and ordinary high watermark estimates for all watercourses within the project scope? Bankful may need to be verified for completeness, but the applicant should provide information on how bankful was determined, whether that was in the field, using reference curves, or modeling. Has the applicant provided turbidity curtain information for in-water work? And also another spot to provide compensatory mitigation information for significant stream channelization, relocation, or enclosure projects. For floodplains, has the applicant correctly identified impacts to work within regulated floodplains? If the applicant is unsure if regulated floodplain is being impacted, the EGLE processor would place the file on hold until this information is confirmed through the district floodplain engineer, or unless sufficient documentation is later provided by the applicant. Has the applicant proposed work within the floodway? If so, a hydraulic analysis must be provided for completeness. And for the site plan section, this is where a lot of the additional information can be uploaded, but it's also where for red files or larger projects, the IPAC determination key output letter would be required. So red files are those projects proposing to impact 1 or more acres of wetland, new construction of a seawall totaling more than 1,000 linear feet, stream enclosure greater than 300 feet, relocation or channelization of a stream more than 1,000 feet total, can potentially impact federal threatened or endangered species or requires other federal coordination. And that would be the all species Michigan D key is the output letter that must be provided. Next, the application is not complete without proper site plans. So in general, site plans need to clearly show the entire proposed project, all of the regulated resources, and all of the impacts proposed in those regulated resources. They should be clear and easy to understand and shouldn't be so cluttered with additional information that they're difficult to interpret. This list and the list in the JPA does not include everything that needs to be on site plans, but they are reminders of several items that are often missed. Scale, compass north, property lines, fill and excavation areas with associated amounts in cubic yard volumes, any rivers, lakes, ponds, and associated ordinary high water marks or wetlands, exterior dimensions of structures, fill and excavation areas associated with the proposed project, dimensions to other structures and lot lines, topographic contour lines when applicable. In particular, for linear stream projects, the applicant should provide a longitudinal profile that covers the length of all regulated sections of the project. Recorded easement boundaries should be clearly identified on site plans to indicate where the applicant is able to complete the proposed activities. Any areas where easements have not been obtained should be clearly identified, and all easements must be obtained prior to permit issuance. Individual crossings for utilities must be identified. If the crossing is using the open trench method, clay plugs must be shown at the wetland-upland boundaries. And cross sections for each impact type and/or structure must be provided. We do accept typical cross sections for similar structures and impact types, but that should include all of the same basic fill excavation details. We would want individual cross sections for each unique impact type, for each unique impact type. For floodway encroachment, cross sections that show existing and proposed occupation and specify the cut and fill side slopes are required. For floodplain impacts, a site development plan showing contours at sufficient intervals to describe existing versus proposed alterations is required. And then the site plan must also show any proposed structures and limits of the alterations. For inland lakes and streams, the plans need to provide locations and dimensions of adjacent structures, particularly for docks, piers, mooring structures, and then parcel boundary lines must be provided and include distances from property lines or riparian interest boundaries to the structure. And lastly, fees. The application is not complete without the appropriate fee. The applicant may have marked unsure under the permit category sections, in which case the permit reviewer will assist with making that determination and notify the applicant of the appropriate fee. If an additional fee is required because the application needs to be modified, EGLE will send a correction request that details the remaining fee amount required. For interagency payments, otherwise known as IETs, the IET number must be provided for completeness. Okay, so that covers the big points of the checklist. Let's talk a little bit more about correction requests themselves. So MyEnviro has been developed to include electronic correction requests. And this system was developed in a way that quickly and easily allows permit reviewers to indicate where on an application there is additional information needed, and it directs the applicant right to the correct section for response. It also allows the applicant to provide a written response right in that section or modify the entered information, provide comments, etc. This system significantly reduces confusion over what and where EGLE is asking for specific corrections to be made, and it makes it quick and easy for applicants to respond directly. As I covered earlier, EGLE staff have 30 calendar days to review an application for completeness. But if there is information missing, if the application was not completed correctly, if there's conflicting information, then the application can be placed on hold until we receive that information via correction request. The 30-day clock stops and does not resume until all that information has been received. If during the application review process, your application is determined to be incomplete, you will receive a notification in MyEnviro, and you'll get an automatic email from MyEnviro. You may also be contacted separately by the permit processor requesting clarification, amplification, or correction. And then you'll have 30 days to provide all the requested information to make the file complete. Or we will provide a courtesy note and reach out to close the file if we don't hear from you. So this is just a screenshot of what the MyEnviro application looks like and a typical correction request item. In this case, while the applicant put some writing in the box, they didn't really address the question and did not provide an alternatives analysis. So the processor has created a correction request for the specific item. It highlights it in orange, and then they provided some additional direction and comments on how this question needs to be completed. The JPA does also have the option for EGLE staff to send the applicant a note, which staff will often utilize for improving communication with the applicant. So think of the correction request as what you need to provide in order for EGLE to public notice the file if necessary and ultimately make a permit decision. But think of the notes as a way to help you understand the correction request or be made aware of important next steps. So CRs are going to contain instructions for incorrectly answered required JPA questions, insufficient answers on the narrative portions, and did you correctly select MPGP category or not? The notes are going to be for the forward-thinking permit process improvements. For example, if the applicant needs a simple modification to meet an MP category, we'll tell you that because it often will result in a cheaper and quicker permit process. Notes can be used to express minor concerns with the proposed project impacts, and then also used for general communication on overall process, next steps, deadlines, etc. EGLE staff might need to inform you that the proposed project is a red file and what that means for your application. They can also be used to identify when EGLE has significant concerns about a project, and addressing those and having discussions with EGLE early on can reduce permit timeframes and costs for the applicant. Okay, we often get a lot of questions on Part 13 and how long administrative completeness takes and where we're at in the process. It is EGLE staff's responsibility to keep track of their files and pay attention to when new submissions come in, and it can be complicated in some cases. But this is a very simple example of an administrative completeness 30-day countdown. So let's say the application was submitted by the applicant on May 1st. It usually takes a day or two to get assigned to the right staff person, but May 1st is when we're starting our countdown at day 30. Let's say the permit processor wasn't able to review the application until May 20th, but on that day, they noted some items that needed correction. May 20th means there are 11 days left in our 30-day review period. But because there are corrections needed, the file is placed on hold and correction requests are sent out to the applicant via MyEnviro. Now, the turnaround for the correction request on the applicant's part was pretty quick, and those were resubmitted on May 25th. The permit processor was able to review those on May 31st and determine that everything was received and the application can be marked complete. Oops, what happened there? Okay. Let me get my spot back. Okay, so yes, the permit processor was able to review those on May 31st and determine that everything was received and was marked complete. The clock was ticking again from May 25th until May 31st, since everything was submitted completely. And EGLE staff still technically had 5 days left for their review, but since they completed their review on May 31st, within that 30-day active period, the completeness date is May 31st. Okay, here's a bit more complicated example, but something that is fairly typical. Let's say it's a similar scenario in that the application was submitted, CRs were sent, the application was returned on May 25th. However, in this case, the responses that were provided to the CRs did not address everything requested, so EGLE had to reopen correction request. In this case, the file did not come off hold, and the clock did not start ticking again because the application was not submitted with all the complete information that was requested. So on May 31st in this scenario, EGLE staff still have 11 active days to review the file. Let's say the second round of CRs were returned on June 1st, but EGLE staff didn't review the file until June 14th. Now, after reviewing on June 14th, they recognized that all the items were addressed on June 1st, so the clock started ticking again on June 1st, and June 12th would have been when EGLE's 30 days were up. That means that EGLE has to backdate the completeness date to June 12th, and the processing deadline would automatically calculate according to that administrative completeness date. Okay, 14-day letters. EGLE staff do send these out if the applicant fails to respond to a correction request within 30 days. And in these letters, it provides an additional 14 days for the applicant to respond to the correction request or respond to EGLE with a request for additional time. If EGLE does not get a response in 14 days or additional coordination, it is EGLE policy to close out the application as withdrawn by the applicant and then send a follow-up letter confirming that closure. An applicant can request more time to respond to the CR, but they should state why they need that time and be able to provide a reasonable date with which they will provide that information. A file that is closed due to an incomplete response cannot be reopened, so the applicant would be required to submit a new application. These are some best practices to consider for the JPA and with correction requests. The big ones are obviously to utilize the checklist and utilize the instructions that we have. The screenshot on this slide is showing those help boxes that appear if you hover over the question. The administrative completeness checklist is designed to help both internal staff review the JPA, and it is designed to help external applicants understand some of those more nuanced questions. So that should help, but our goal is to have staff conducting completeness reviews within a week of receiving an application or receiving your responses to the CRs. Staff will try to include everything in that first round of CRs. This gets back to some of the Part 13 requirements, but it's also just good customer service and good practice. EGLE policy is, to the extent practicable, identify all the completeness issues the first time around for the applicant, so it isn't a moving target. But on the flip side of that, the responses by the applicant should also address all aspects of the correction request at one time. If there were multiple items or questions, address each item and answer every question, or else the correction request could be reopened. Be as clear as possible and provide EGLE with information on what you modified or corrected in the JPA. EGLE staff will try to provide explicit instructions on what needs to be corrected. Staff will try to give you specific pages and locations on where items are missing or need to be corrected, but it is helpful if in your responses you also inform EGLE staff where those changes were made. And then finally, just maintain open communication with EGLE staff and utilize those pre-application meetings to discuss what items should be included. So with that, applicants do have a couple of options for EGLE assistance when it comes to planning a project, essentially for improving communication and coordination with each other, as well as smoothing the permit process and administrative completeness review. EGLE offers the Wetland Identification Program. This is a delineation provided by EGLE for projects up to 5 acres in size or confirmation of a consultant's delineation. Pre-application meetings are also available to request an on-site meeting or in an office meeting or a virtual meeting for a small fee to discuss the project and determine if a permit will be needed. This differs from the WIP in that it is more discussion-based, but during a pre-app, staff can determine if wetlands are present in the project area and whether a permit would be required, but staff will not delineate the wetland or confirm wetland boundaries in a pre-app. I've got a couple slides on general tips for a productive pre-application meeting. You know, the pre-app meeting is designed to discuss more specific details of the project. It's definitely not necessary for every project. For example, simple activities covered under MPGP categories. But for those more complicated projects, we definitely recommend the pre-app meeting because it's also a great opportunity for both the applicant and EGLE processors to communicate any potential concerns, which hopefully will make the application go a lot more smoothly when applying. But we recommend applicants submit a request as early as possible in the planning process prior to submitting a permit application. Ideally, it's at a good stage that we have good preliminary information because you want to include as much information as you can, but early enough that if we're discussing significant modifications or action items, that those can be done with enough time to submit a permit application. The more information provided in a pre-app, the better prepared EGLE staff can be, and then the more productive the meeting. A few key items is to provide information on all of the water resources potentially impacted by the proposed project, provide any preliminary plan designs or wetland delineations, and include your project purpose. Also beneficial, tell EGLE staff what you want to get out of the meeting. Are you looking for an answer to a specific question, or do you want to make sure EGLE staff touch on certain topics? EGLE staff should be doing a preliminary review of the project area anyway, but sometimes the meeting request that we get is very vague and we're not sure what the project is or how best to help you. So providing that information will also help inform EGLE if we think there are specific discussions that need to be had, like mitigation, red file processing, restoration, etc. And then from a timing perspective, just keep in mind that the time of year and type of request can impact how quickly the meeting can be scheduled. So, this time of year up until early fall is really the busy season for EGLE. A lot of site visits are taking place. A lot of permits are being applied for. So on-site visits may need to be scheduled out further. Virtual visits are great because they can be easier and quicker to schedule, but then keep in mind that on-site visits may be necessary for EGLE staff to provide specific guidance, or sometimes the site is just better understood by seeing it on the ground. And then wetland determinations are very difficult in the winter. So if there's a foot of snow on the ground, don't be surprised if EGLE says that they're not able to make that determination until the spring. So hopefully I was able to provide some clarification and good information on Part 13 and administrative completeness. We recognize there's going to be a lot of complicated files, situations that don't fit the JPA perfectly, but in those situations, communication with EGLE and your local district permit processor is pretty key. So definitely reach out with questions, take advantage of those pre-application meetings, provide follow-up, clear details, and EGLE will strive to provide good communication to you as well. So that is all I have.
Thanks, Kate. I don't see any open questions. Go ahead and type any questions people may have in there. And
Yeah, so Todd, I've been trying to answer questions as we go along. Some of them were kind of specific to, I think, specific projects, so we probably won't answer those with everyone. And some of them were things that Kate was going to cover later in the presentation. So yeah, I think if you all have questions now that Kate is done, we can open it up for that.
so I will say, Kate, I mean, I'm a big fan of my Enviro. I think people may be surprised if, because I wouldn't have said that a few years ago, right? It was pretty clunky. It's still got some clunkiness to it. Some of the stuff is not real easy to fill out. Some of it's not easy to see, but the correction request part of it specifically, as well as where staff can put questions that they're going to have during the review, I think is very helpful and just really works well. So I think you guys have done really good in improving that, and the process of filling out the online form versus what the hard copy used to be is a significant time savings. There's no doubt.
Thanks, Todd. I know our staff, I agree. When we first launched, it would have been, My Waters at that point. Now it's My Enviro. It definitely has been improved since then. And so we are trying to both streamline the process for applicants as far as getting us the information to look at the projects, but also try to save time for our staff. So, we're trying.
Oh, I think that's clear, for sure. Okay, I don't see any other questions, so thank you, Kate. Always like having you guys, and we'll get this up on the YouTube channel so people can pass it around to their friends, because I'm sure we'll get a lot more views.
Thanks, Todd. Thank you, Kate.
Thank you. Yeah, thank you guys. Any questions, let me know.
Take care, everyone.